Good afternoon and welcome everyone to today's program. My name is Amal Qutb and I'll be your host for today. Bismillah ar-Rahman ar-Rahim. In the name of God, the most compassionate, the most merciful. Assalamu alaikum wa rahmatullahi wa barakatuh. May peace and blessings be with everyone joining us here today. We'd like to begin by acknowledging the land that we are on today. While we meet today on a virtual platform, I would like to take a moment to acknowledge the importance of this land that for thousands of years, Indigenous people inhabited and cared for. We are grateful to have this opportunity to work on this land, and by doing so, give our respects to its first inhabitants. Welcome everyone to today's program. My name is Amal Qutb. I'm the Emergency Response Support Coordinator at DEEN Support Services. And for those who are unfamiliar with DEEN, DEEN stands for Disability Empowerment Equality Network, and we are a registered Canadian charity founded by Muslims with disabilities. We operate a number of programs and services in Mississauga, Ottawa, and Scarborough, and we serve all individuals with disabilities and their families regardless of their religion, language, and culture. We encourage you to connect with us on social media and email us at info@deensupportservices.ca. And this information will be shared with you in the chat very shortly. So just some housekeeping notes before we begin. This meeting is being recorded and it's intended to be uploaded online at a later date. We'll start off by a short presentation by our guest speaker, Lawyer Zafir Khan. During the presentation, feel free to type in your questions in the question and answer box or the chat box, but we'll be taking time towards the end of the presentation to address all the questions, just around 1:05 p.m. And if at that time you'd like to ask the speaker directly your questions on camera, feel free to press the raise hand button and we'll unmute you so you can ask your question directly on camera. So today's webinar is the first of 3 webinars that focus on various legal matters that are important to everyone, and specifically people with disabilities and their families. And specifically for today, the focus will be more about the importance of preparing a legal will. Oftentimes in my conversations with families, they've expressed a lot of interest about knowing the importance of preparing a legal will, but just not knowing where to start. And oftentimes the process feels really overwhelming for them. So we really hope that from today's webinar, many families can feel empowered to take the first step towards this. So without further ado, I'm happy to introduce to you our guest speaker today, Lawyer Zafir Khan. Lawyer is an associate at Rutman & Rutman Law Firm. He's played an integral role in supporting many of our DEEN Support Services participants and families. And DEEN is currently offering a subsidized legal will preparation service in partnership with the law firm as well. More information about this will be provided towards the end of the presentation. So without further ado, I will pass it on to Zafir Khan.
Assalamu alaikum, everyone. I hope everyone is doing well, considering the circumstances. I know there may be a little bit of fatigue here with respect to our first and second waves, and I trust everyone has been keeping healthy and has been coping with the pandemic that has now been going on for a year as of tomorrow. Having said that, the pandemic has, from our perspective and from our experience, brought about thoughts of our mortality. So what we have seen through the past year are questions regarding preparing for your will, your estate, questions regarding what would happen with respect to our family members when we pass away. And those questions become a little bit more real as we face our pandemic. And so today I'd like to go through, we're going to have three sets of seminars here, this being the first one. Today we're basically going to be going through the legal requirements of a will. What do we need when we have a will? What should we think about when we want to prepare our will? And what sort of concepts are we thinking about? Because a lot of people think that a will is complicated. A lot of people feel that preparing our will is time consuming and it's confusing and it's complicated, and because of that, a lot of people, what they have done is they've actually procrastinated on preparing a will. A lot of individuals feel that this concept of preparing a will is just too much to consider, and as a result of that, these decisions are either not made or are made when it's too late. And that leads to another set of issues that we'll be covering in other seminars. What I'd like to do today is actually share my, some thoughts and a PowerPoint presentation that I've actually prepared that we can actually go along with as we work through this. So what I'd like to do actually is to, start our presentation first by a short disclaimer. So today's webinar is only meant to be informational. So it's not supposed to be legal advice. It's not considered to be legal advice, nor should it be construed as legal advice. And that's one housekeeping thing that I want to discuss. We are providing information only. And so please do not consider any of this to be, legal advice or you retaining our firm. If you choose to do so after attending our seminars, I'd be glad to assist you in further detail. But for now, what we want to do is basically provide some basic background and some information that you should consider when preparing your will. And so I'd like to start off first by mentioning a hadith of Prophet Muhammad sallallahu alaihi wasallam, which can be found in Sahih Bukhari, sorry. And the Prophet Muhammad sallallahu alaihi wasallam says that it is not permissible for any Muslim who has something to will or to give from their estate to stay for 2 nights without having his will and testament written and kept ready with him. So a lot of the scholars, when they look at this hadith, they've advised that it's scary in the sense that a lot of us have gone 2 nights without having his last will and testament prepared. So they look at the provisions in Surah Nisa and Surah Baqarah, certain ayat where Allah subhanahu wa ta'ala sets out the provisions for distributing your estate and, makes it incumbent upon a Muslim to have a will if they have any assets to bequeath or to provide. And so that's what I want everyone to consider. As we work through this framework and as we go through this process, consider it to be an obligation. It's a religious obligation for anyone who has assets to have a will prepared. And so that's the guiding principle. So what is a will? And that's a very simple concept. So a person's will is a written document that sets out the person's wishes about how his or her assets should be taken care of and distributed after their death. And so this is a common misconception as well. People, we will speak about power of attorneys on another date, but people speak of their power of attorney and their will being interchangeable. And it's not interchangeable. Actually, they're 2 separate documents. So a legal will takes effect when a person dies. A power of attorney actually takes effect when a person is alive and incapable of handling their own assets or their own care. That is only applicable when someone is either mentally or physically incapable of taking care of themselves, that being the power of attorney. The power of attorney no longer governs when a person dies. It's the will that then governs. So please keep that in mind, that the terminology may be used interchangeably, but it's important that you don't use it interchangeably. That a will is a document that governs when someone passes away, and a power of attorney is something that governs when someone is alive but mentally or physically incapable of taking care of themselves. Now, what are the legal requirements for a will? I'm going to be providing some legal terminology in parentheses, so it may be used interchangeably, but a person making a will is called a testator. And that person must be of sound mind. In other words, that person must be mentally capable of making decisions or providing instructions. So lawyers, when we meet an individual to prepare their will, one of the first things we'll be looking at is to see whether or not that person is of sound mind or mentally capable of making decisions, providing instructions, and understanding what's being said to them. It's not a very strong or high threshold. The person generally should know who they are, should know, generally speaking, what their assets are, and should generally understand what we will be speaking of afterwards, the certain decisions that have to be made. Now, being of sound mind also includes being over the age of 18. You have to be an adult in order to have a will. If you're under the age of 18 but you have assets, it's generally understood that your legal guardian would be the one who would make decisions regarding your estate. A will must be in writing. So it has to be actually be a paper copy. Although we've moved forward in terms of technology and moved forward in terms of keeping soft copies or electronic copies or clouds, as it may be, Ontario hasn't yet recognized an online or soft copy or electronic will per se. There's no case law on this. So still, although we live in an age of technology, a will must be in writing, on paper, and signed. And signed by whom? Signed by the person making the will, the testator. Now, if the will is handwritten, and the law, since the law on this case law on wills and testaments have been developed, recognizes that a will can be handwritten. So someone can actually scribble down something on a piece of paper and sign it, and that's their will. Certain case law actually looks at the fact that an individual doesn't even have to sign it with their normal signature. It can have initials, it can have anything indicating that this is the person's will. There are case law out there that a farmer was working on a farm, the tractor falls on the farmer. The farmer, knowing that his life is coming to an end, indents or writes on his tractor everything to my wife, and scribbles initials on the tractor, and that case was taken to court, and that was considered to be a will. So keep that in mind as well, as I spoke about at the beginning, that complicated, not complicated, whether a will can be complicated, it necessarily doesn't have to be, right? In the individual for a tractor, he basically scribbled down something on the tractor, and that was considered to be his will. So that's with regards to a handwritten will. If your will is not handwritten, and this is complicated, so the case law looks at what is a handwritten and what is not a handwritten will. In order to qualify as a handwritten will, a will must be solely in that person's handwriting. In other words, if you take a pre-populated document, let's say you download something online and portions of it are typed out and portions of it are handwritten, that is no longer considered to be a handwritten will. That is considered to be, it's not a holograph will. You'll see I use that terminology in parentheses. It's considered to be a written will, but not handwritten. And if it's not handwritten, it requires the signature and the witnessing of two unrelated witnesses. Now, what is an unrelated witness? In order to qualify as a witness of someone's will, you have to be over the age of 18. You cannot be named in the will as either a beneficiary or an executor. You cannot be the person's spouse or child. So there's certain rules to keep in mind when you're writing your will. If you choose to do so yourself, and by all means, there's nothing preventing you from doing that, you have to ensure that you have two witnesses that witness you signing your will in your presence, and that person cannot be either an executor in the will, either primary or substitute. We'll speak about that later. Cannot be a beneficiary of your estate, and we'll speak about that later as well. Nor can they be your spouse or your child. The reason, or the spouse of your child. Now, the reason being is that what the law looks at is that they want to make sure that there's no coercion or duress or force when you're signing your will. No one's forcing you to do the will. And the law recognizes that certain people may have certain influence over an individual when they're making the will. Now, in the times of COVID, the Ontario government has passed certain regulations that allow wills to be witnessed virtually. So, one person could be in one room, another person could be in a totally different part of Ontario, and witness that individual signing their will virtually. That's an aside. That's something we can discuss if you were ever to choose to do so after the fact. Now, people often ask, what should I include in my will? What makes a will a will? As I mentioned in the individual with the tractor, it was very simple, everything to my wife, but he didn't include a lot of information in there. And we would caution individuals to put a sufficient amount of information in your will so as to, not be challenged in court. Now, anybody can challenge a will if they're a beneficiary or if they deem themselves to be worthy of being a beneficiary of an estate. And so in order to avoid that, you want to have some information in there in your will to ensure that that doesn't happen. So what information should you include in a will? First, we look at your executor. So in layman's term, we call the executor the executor. In legal terminology, we refer to that individual as the estate trustee with the will. And the estate trustee with the will is tasked actually with the most important decisions and tasks once you pass away. So the responsibility of an executor includes calling in your assets upon death. And when we say calling in your assets, it means determining or ascertaining what assets you owned in your own name on your death. They would have, that individual, he or she would have to, either go through any documents you may have in your possession, your bank accounts, your deeds, your investment portfolio. So, I mean, this person would have to have intimate knowledge of what you own on your death. That person would then have to transfer any assets or ownership to an estate, to your estate. That could entail transferring assets to, an estate account. It could be to convert any assets that transfer over to a beneficiary directly through life insurance, for example. I had to do that yesterday for a client who had to transfer over, life insurance, either shares or bonds or assets directly to a beneficiary. It would include paying off any debts owed on your death, any taxes, any expenses, and then the person would distribute the assets to your beneficiaries. So it's time consuming. It's a lot of work. It entails a lot of thought and time. So this is exactly why we say when you're choosing your executor, to choose an individual who has knowledge of your assets or who can responsibly undertake the tasks of an executor. You want to choose someone who is sufficiently knowledgeable, who is responsible, who you feel is capable of undertaking this task, because it's time consuming. If any one of you have experienced death in your family and have either personally or through secondhand seen what an executor has to go through, it's quite substantial. And it's sometimes can be frustrating. It sometimes can be stressful. So that's why you want to have someone or choose someone who is sufficiently knowledgeable or responsible enough to handle this task. Right? Most individuals, therefore, will choose their next of kin. They will choose their spouse or they choose a child to handle this, and that goes to an individual having intimate knowledge of your assets. Most spouses know what the other spouse owns on their death. Would be involved in going to the bank or dealing with the wealth manager or the asset manager. So that's why we would advise most people to choose a spouse to be the executor or a child. That doesn't necessarily have to be the case. You can have a very close friend who can act as an executor. Some individuals use the individual at the bank who knows their investment portfolios or investments or bank accounts to be the executor. Some people choose lawyers to be their executor, and typically would not want a lawyer to do that, simply because there's certain other reporting requirements that a lawyer may have. And then what we would typically advise individuals is that if you're choosing an executor, you should also choose a substitute. And it's very simple. The reason being is that it could be foreseeable that your executor, the person you've chosen as an executor, is either incapable or unwilling to act as an executor at the time, or that they've predeceased you, they've died before you or died at the same time. So you should always choose a substitute. And again, most individuals choose their spouse as a primary executor, and then their substitute executor would be a spouse or a parent or a brother or a sister or a very close friend. Now, after you've chosen your executor, the next portions of your will would be the division of your estate. And your estate would be your assets that you own on your death. Now, this is an important point. What forms your estate is actually only the assets that you own in your name only. And so the law looks at joint assets. Joint assets could be in the name of houses or in bank accounts. Um, those assets do not form part of your estate. That the right of survivorship actually transfers directly over to the other joint account holder or the other joint owner of your house. There's reasons why you would do this. You would want, there's probate taxes that you could save by doing this, and this is something that gets a little bit more in depth when you're doing estate planning. For simplicity's sake, your anything that you own in your own name alone is what forms part of your estate. Now, the next question you would say is that, well, who are my beneficiaries? Who do I want to gift my assets to when I die? And again, most people choose their next of kin as their beneficiaries. You would typically see that, an example would be, please transfer my entire estate to my spouse upon my death. And if my spouse dies, then the remainder of whatever I own on my death should be transferred to my children equally or in fractions or in parts. Now, there are other beneficiaries and other assets that you can transfer. Oftentimes, and you'll see this point below, that you should, oftentimes people will consider Sharia law principles on the division of their estate, which would then entail thinking of charitable donations. There's also gifts of personal effects that we speak of: jewelry, collectibles, hobbies, mementos, personal, very special, assets that people have. I've seen people with card collections, coin collections, vintage cars. Not saying that everyone would have that, but there are circumstances where individuals have very personal items that they own that they would want to transfer over to a specific individual, someone who shares that passion with you, someone who is dear to you. And so you would want to make sure that you have sufficient information in your will that clearly sets out who is to receive what. Now, I don't speak about this in the actual slideshow. Other individuals want to, they look at their kids and they say, well, I don't really want to give my kids everything that I own at the age of 18 or 21. Is there a way that I can, provide this in steps or stages? And that's possible. You can always say that I want, my children to receive, 50% of what they're entitled to at the age of 21 and the other 50 at the age of 25 or any other age that you would want to. And that's a lot more detail. For the purpose of having a will, you should have your beneficiaries. You require beneficiaries in a will, and some sufficient detail as to what assets are being transferred. Now, the next indication, or that often people have, is that they want to ensure that they have their funeral wishes in their will. Now, funeral wishes, we always caution our clients that they're not binding on your executors. And there's a very simple reason why they're not binding on executors. It's because a will is usually not disclosed until after a person has died and their funeral has happened. Having said that, funeral wishes are mere wishes, but they act as guidance to your executors. And so what I typically advise my clients is that, if you do have a funeral wish, you should probably advise your beneficiaries and your executors that this is what you want to have happen when you die, or make that specific provision of your will clear. Now, when we say funeral wishes are not binding upon your executors, the other reason why we say that is because beneficiaries cannot sue an executor for not following the wishes of the deceased. In other words, often, many people will have already, purchased their plots of land. They may have already made decisions as to what kind of funeral they would have. Obviously, in Islam, we have very strict requirements as to how a body should be handled and what should happen to the deceased. Having said that, you cannot sue. One cannot sue an executor for failing to follow those directives. You also have to ensure that, oftentimes a person would say, I want to be buried in a specific cemetery in a specific plot of land. But what would happen if that person dies in another country and they, the wishes were also that they be buried in the place where they die, that they don't want to be transported from one country to another. You know, all of these things have to be taken into consideration, obviously, but we always make it explicitly clear that your funeral wishes are not legally binding on your executor. Having said that, there's benefit to doing it, and that's why that's something you could put in the will, and oftentimes individuals do put that information in their will. And so here's a general checklist that you would have when making your will, and this is always important. So A, who is your primary executor? Who is your substitute executor? Who would you want to act as your executor should that primary executor either die before you or be incapable or unwilling to act as your executor? Do you have any charitable donations that you'd like to make from your estate? Do you have any jewelry or personal assets, collectibles, mementos, hobbies, very personal assets that you'd like to gift to specific individuals, right? And so we typically advise our clients that if you do want to do so, that you make that specific item sufficiently clear in the will, and that you put the full legal name of the beneficiary who is to receive that asset. Yeah, and then who will receive the remainder or the residue, what we call the residue of your estate, after the distribution of any charitable donations or distribution of assets of personal effects. Again, it can be divided by percentages, by fractions, by relationships. Again, many people will wish to have their estate divided according to Islamic Sharia law, and that may be a question that arises when someone may have that question as we get into Q&A. And then last, do you have any funeral wishes? And again, very, very simple checklist, and very simple outline as to what is required to make a will in Ontario. And having said that, I'm open to questions. If anybody wants to ask any questions with regards to how to prepare a will or what's required to do a will, I'd gladly take that. Amal, you're free to do that if you wish to.
Thank you so much, Zafir, for that comprehensive presentation. And I really appreciate what you said earlier. A lot of times we get so overwhelmed by just the thought of making a will or getting started. Of course, I'm not advising everyone to write on the side of their tractor everything to my wife or everything to my spouse, but it's just something as simple as, what are your wishes? Have you written them down? And probably this is a good segue into our first question for today, which is, if I can actually write down my will on a piece of paper, why should I go to a lawyer to help me document a legal will?
It's a good question. So again, lawyers will assist you in terms of making what I just pointed out sufficiently clear to you, and they'll also advise you as to estate planning, as I just mentioned, right? So a lot of people will go to a professional estate planner to plan out their estate, and then those wishes are then, instructions are then provided to a lawyer who would then prepare the will. Now, what I've provided in my handout or my PowerPoint presentation there is extremely simple. However, there are certain legal protection clauses that we place in a will that other people will generally not know. For example, one protection clause that we have in a will is in terms of an indemnity to an estate trustee, to an executor. And in our standard sample wills, we have about 6 paragraphs that are indemnity clauses to our executors. You typically do not want to bog down your executor and open them up to lawsuits. I've actually had a client who was very concerned in terms of, okay, someone has named me in the will as an estate trustee and as an executor, and I really don't want to do this because I'm so afraid of what would happen if I were sued. And the Toronto Star had an article that prompted this fear. And so protection clauses or indemnity clauses in the will would include an indemnity to the executor should they have to invest any assets into specific accounts, that person be free to do so. Indemnity clauses in terms of if the estate or the deceased person is sued, that person can then handle that lawsuit on their behalf and cannot be sued by a beneficiary should they choose to do so. Certain indemnity clauses as well is that if funds are held in trust for a child, that child cannot then challenge the estate trustee in terms of the decisions they've made, because as long as they're doing so for the benefit of the beneficiary and not to the detriment. That's where the lawyer comes into play. There's a last clause, protection clause, that's put into a will. It's called the Family Law Act Protection Clause. Generally speaking, any asset that is obtained through an estate is not subject to Family Law Act division, and this is very complicated. So what that means is that should a person obtain from or become a beneficiary, and should that person be married, the spouse cannot claim from that estate, except if the beneficiary invests those assets into joint accounts or matrimonial homes, etc. And so that's where the lawyer comes into play, because that's very complicated information to provide to a deceased person that they would otherwise not know. So that's why I would strongly advise individuals to seek legal counsel, seek a lawyer to assist in making those decisions.
Thank you for that. And I would like to remind all the attendees that DEEN Support Services is currently accepting applications for the legal will subsidy that we're providing to 25 individuals. So for all the attendees that have attended today's webinar, you'll be emailed that application. The last day to submit to be considered for the service is March 22nd. So again, it's to support individuals to access the services of Zafir's firm in completing a legal will at a subsidized cost. So I would like to encourage anyone else who has any other questions, you can type them into the Q&A box, or if you would like to ask them directly on screen, you can click on the raise hand function and we can unmute you. We do have a lot of other questions that were submitted. So someone here says, I don't have any assets. In fact, I just pay rent and live month to month. I receive ODSP and I don't really own anything else. I have children, however, should I still complete a legal will?
Yes, in the sense that you never know when you come upon assets. And so that's very common. People say that they don't have any assets. They have very simple assets. However, you still may or may not come into assets. You may get your own inheritance, or you may obtain certain assets through the course of time and just forget to do your will, and then all of a sudden it's another issue, right? That you've died without a will, and now your beneficiaries then have to apply to the courts to have the assets divided according to statute. The other thing I wanted to point out, I mentioned this in previous seminars as well that we've had, that a common misconception is that if you die without a will, the government takes everything, and that's not true. There is a statute called the Succession Law Reform Act, which is the legislation that governs how assets are divided, and it also speaks to what happens if someone dies without a will. And what typically happens is if someone is married, then the spouse gets to elect either the first $200,000 of the person's estate, or they can elect under the Family Law Act for half, and then the remainder is divided according to children and spouses equally.
Thank you. So we have a question here. Thank you for the content. Can you repeat the notion around witnesses during COVID-19?
Yeah, so simple, very simple. So after COVID-19, after the pandemic began, I believe it was in April or May, the Ontario government passed a regulation. It's not permanent, it's just a regulation, it's not legislation, that allows a will to be witnessed virtually. And so what that means is that if we're on a Zoom call, as we are now, and Amal, if you're signing your will in front of myself and another individual, I can witness you signing that will virtually. So you can sign the will as you are in front of me now. I and another individual, as I mentioned, who's not related to you, can then witness you signing the will virtually. And what would happen is that we can then transfer it to each other. So you can courier the document to me, or mail it to me, or hand it over to me at a later date. I can sign my portion as a witness, and then the other individual who's witnessed you virtually can then sign as a witness as well. What we would typically do, and this is where a lawyer comes into play as well, is that there's a document called the affidavit of execution. This has to be provided whenever you pass probate. We'll speak about this in another seminar. that would have to be filed with your will to confirm that we have witnessed you signing your will, and we would have to put a regulation that we've complied with. I can see someone's asked a question with regards to Firdaus. You've asked, can your will include international estate that you own apart from what you have here in Canada? It's a good question. You can. However, having said that, a will that is made in Ontario cannot necessarily govern assets that are owned outside of this jurisdiction. What would happen is that you should either have a separate will made in the jurisdiction in which you own that asset. So for example, if you have assets in the United States, you should probably have a will made in the United States. Having said that, if you were to note your international assets in the body of an Ontario will, once you pass probate, once you get a court order confirming, or your estate trustee gets a court order confirming them as the estate trustee or the executor of the estate, that person would then have to go to the jurisdiction in which your asset is located, and then have that court order enforced in that jurisdiction. It's a very complicated, route of passage that you have to pass through. So the best thing to do is to have the will made in the jurisdiction in which you have that asset. Having said that, if you don't do that, and if you only have an Ontario will, it doesn't mean that your wishes are null and void. It's just that you have to go through extra step.
Thank you for clarifying that. And someone here asks, how much does it charge to write a will?
So I guess we can speak to that in terms of the subsidy at another time. That's probably the best way to go by that question. If you do have that question, please direct it. You can direct it to Amal, or I believe Faiza is also assisting for Dean, and we can work on that.
Yeah, and that speaks to the importance that every firm works differently and every situation is different. Everyone's needs is very different. For us specifically, the subsidy that we're providing is $175. So for $175, we're supporting individuals to complete and prepare a legal will. So again, we will email everybody a copy of that application. And you are more than welcome to also contact Zafir's firm directly to inquire about your specific needs and how that might look like for you. But thank you for that question anyways. So the fourth question is, how often should we update a will? And actually this is connected to another question, is that what if I change my mind? How often should I go back and update it? Is it easy to go back and update it? How frequently should a will be updated?
It's a good question. So typically speaking, we would advise someone to change a will if either the asset mentioned in your will has changed or is no longer present, or if the individuals named in your will are no longer present. A simple thing. If you have a house, and this is another reason why you should see a lawyer with respect to wills, is that a lot of people mention the address of their existing home in the will. So they would say, I live at 123 John Street, Toronto, Ontario. And for example, if that individual sells the property and 123 John Street is no longer a personal asset of yours, then, let's say you purchase 255 Queen Street, Toronto, Ontario, hypothetically. Then since 123 John Street no longer exists as an asset of yours, that asset actually goes, it becomes a part of it. It doesn't become a part of the will. So you can't govern the will. It doesn't be governed by the will anymore. And what would happen is that then that asset would go over to what's called the rules of intestacy, because it hasn't been covered in the will, and it would be governed by the legislation, not the will anymore. So if your asset that you've mentioned specifically in the will is no longer present, then you should change your will. If individuals who you've mentioned in your will are no longer present, let's say, for example, you've mentioned someone specifically in your will and they've passed away, you should probably amend the will. Having said that, if the individual is no longer alive, we typically advise you to have protection clauses in the will as well, to say, for example, should Muhammad Ali pass away, for example, prior to my death or die within 30 days, his share shall go to Hassan Ali or Akbar Ali, for example, hypothetically speaking. That's why, you don't necessarily have to change the will all the time if you make your will sufficiently clear. If you don't have those protection clauses, and if Muhammad Ali and Akbar Ali and Hassan Ali have passed away, then you would definitely want to update your will. Now, if you change your mind, no, there's no issues. You can prepare what's called a codicil. A codicil is an amendment to a will, and basically what it would say is that, you know, with respect to clause A in my will, please delete and insert clause B.
Thank you for clarifying that, and I think it speaks to the importance of working with someone who actually works in this field and then does legal wills all the time and has the experience to be aware of, like, you know, protection laws and such that probably for the average person is not aware of. So this question is, if I have a lot of money in my bank account and I die and I have a 5-year-old son, how would my sister access my money in my bank account if I have a sudden death and my 5-year-old is my beneficiary?
It's a good question. So we'll be speaking to trusts and Henson trusts at another day. Now, Henson trusts are very specific. That's with regards to individuals who have disabilities. Trusts are created in the body of the will itself. And so what you would do if you have a minor, a child who is below the age of 18 or any age that you've indicated in the will, as I mentioned, you could do 21, 25, splits, etc. The will would create what's called a testamentary trust. That's the legal terminology that means that any assets that are to be handed over to a minor is held in trust by the estate, and it is, you know, operated by the estate trustee for the benefit of the beneficiary. Now, there's certain rules now that apply with respect to minors and handling minors' money and funds that are transferred over to a minor. So I want to get into a little bit of detail here. Let's say, for example, put aside the bank account now. Let's say, for example, you have a life insurance policy, or you have an RRSP with a designated beneficiary. An RRSP is considered to be a bank account for the most part. It's just that, you know, you can name your beneficiary directly in the RRSP policy or in the RRSP itself, and that transfers directly over to the beneficiary. It doesn't go into the estate. So if your 5-year-old child, for example, is now named as the beneficiary of that RSP, and the ownership of the RSP is then transferred into the name of the 5-year-old, that 5-year-old obviously cannot handle the RSP, nor can they get the benefit of the RSP. And so you would have to apply to the courts to become a guardian of that minor's property. And you would have to go through the Ontario Public Guardian and Trustee to be the guardian of that minor's assets, right? So there's a 2-step process there. There's a testamentary trust with regards to anything that goes from deceased to estate that the executor can handle. And then there's also considerations with respect to what happens if something flows directly from the deceased to the beneficiary and that beneficiary is too young.
Thank you. Is it possible to have 2 executors rather than 1 and an alternative?
Yes, you can definitely do that. And we typically see this when parents have children, multiple children, either through moral consideration or emotions. They would choose to have children act jointly. One word to the wise, we typically have clauses that with respect to joint estate trustees, we use a terminology called jointly and severally. The difference being is that jointly alone means that your executors have to make the decisions together, and if they cannot decide as to what to do with the estate or a specific, you know, rule that you've set into your will, it goes to court. Because if the 2 individuals cannot come to a decision, then it's at an impasse. Now jointly and severally means that the individuals can make together the decisions either together or independent of each other. Again, we typically see, well, not typically, but we have seen in the past where, you know, individuals or deceased individuals have put jointly and severally, and then the other child doesn't really necessarily like what the other child has done. And then, you know, there's a conflict at hand. So while we definitely allow, or, you know, tell people you can put joint executors or 2 children as executors, you may want to have either a jointly or severally, or just have one child as primary and the second child as substitute. Again, remember, your executor, think of your will as your constitution. Your executor can't do whatever they wish to do in terms of dividing your assets. Yes, they can do certain things with regards to investing specific assets in trusts, and make certain decisions should lawsuits or litigation come up. But they can't just divide your estate the way they want to. They have to follow what you wished for in your will, what you've set out in your will. And if they don't, then there's certain court applications that can be brought to remove that individual for not acting according to the wishes of the deceased.
Thank you. So this question seems a little too specific. So I guess to kind of give you a general idea, it asks here, my mother owns 75% of the house with my brother who is married. There's a lot of difficulties in terms of the way he would like to divide his asset and the way that my mom would like to divide her assets with her other children. What steps should we take? So I guess it sounds like maybe if you own property jointly.
Yeah, that's something for a consultation, actually. That's something we should discuss separately. You can't, that's not so much will drafting, that's more in terms of either potential litigation or mediation, if there's a conflict with regards to how to handle that asset. Generally speaking, if a property is owned jointly, either percentages, and it can happen, you can own 75% of a property jointly, of a house jointly with another individual, the right of ownership transfers over directly to the other individual. If you own a 75-25% split to any property, then an individual, generally speaking, can do whatever they please to do with their 75%, and the other person can do whatever they please to do with their 25%. So that's something potentially you should speak to either myself or another lawyer personally with regards to that specific issue. I see that there's another very specific question in the chat. It says, I see that. My mother owns 75% of a house she shares with my brother. Again, yeah, if your mother owns 75% of the home, then she can will it however she wishes. And if the other 25% holders don't agree with her, then unfortunately, she owns 75%, right? Now, specifically speaking with regards to property that is owned jointly, let's say you own it with 2 people, 3 people, 4 people, there are certain laws that can sever a joint tenancy, and you can bring certain court applications for what's called a partition and sale, but that's very specific litigation that you should speak to us about if you have that question.
The last sentence in that question, it says that everything is just said verbally, and maybe we can use that, as a question in itself. Like sometimes a lot of people express their wishes verbally. Does that stand in a court of law if you express something verbally, or does it have to be in writing, signed, witnessed?
It has to be in writing. Yeah, you can't divide your estate verbally. That it has no bearing. Yeah. Again, if you don't have a will in writing, then irrespective of what someone has said verbally, which again in and of itself is an issue at court, because then it becomes a matter of testing what we call the veracity of what was said or the truthfulness of what was said. In the absence of a written will, everything goes specifically according to statute. That's why the Ontario government has passed for many years, since about 1980, specific laws with what happens when someone dies without a will. So verbal doesn't have much bearing.
Thank you. Does updating asset list requires new signatures and witnesses?
Yes. Every single time you make an amendment to a will, it has to be signed in order for it to be valid, and it has to be witnessed. If it's done, if it's not a holographic will. So yes, every single time you make a change to a will, it has to be signed and it has to be witnessed.
And if you have a spouse and a minor, a 2-year-old minor, should you list your spouse as the only beneficiary for RRSP and life insurance policies, or list both of them, the spouse and the child, and the spouse as a trustee?
Yeah, that's a good question. And again, it goes down to how you would like to handle this. Now, one of the most difficult things we often tell clients is that always remember especially for, well, it could be young or old, it doesn't really matter. I always remember that if you passed away before your spouse and you give everything to your spouse, there's nothing stopping your spouse from marrying someone a month, 2 months, a year, 2 years, 3 years after you die, and everything then is, that spouse now has control of your entire assets and can cut out your children from the will, or can do another will and name people who you have no relationship to in your will. Now, again, that's word to the wise. It's caution to the wind. Most couples don't even think that way, but it is something that we would advise clients that there's nothing stopping a spouse from remarrying, and then the entire estate is transferred over to a new individual or new individuals, and your children then get nothing from the estate. So going back to the question, with regards to life insurance policies or RSPs, there's no harm in naming your children as co-beneficiaries under the policy, according to a percentage that you feel comfortable doing. And the benefit, of course, is that, again, if you want to provide something for a spouse, by all means. If you want to provide something for your child separately, by all means. And then again, this question comes across our desk all the time. What happens if the minor obtains from the RSP or the life insurance policy? It's an application that has to be made to court to be the minor's guardian for their property. But again, it's protection against the spouse taking $1 million life insurance policy and then marrying someone 5 months down the road, and then your child gets nothing, potentially. And it's very coarse. It's very, it's not the nicest thing to tell people, but it's something you have to look at in reality.
And I just want to remind everyone we're headed towards the last 5 minutes of today's program. So if you have any other questions, please plug them into the chat box. Since we're speaking about minors, one question I personally get a lot of times is that, if there are children under 18 and the parents die or pass away, when it comes to their guardian, their guardianship and who takes care of them, there's a lot of fear sometimes that, Children's Aid Society will step in and they'll be taken, put up for foster parenting or whatnot. What can parents do ahead of time? Is this what usually happens automatically? Is that children are passed on to foster care, or what happens?
Not necessarily, no. Actually, foster care is the last resort. That's if a child has been deemed to have no guardian whatsoever, or no, reliable guardian. Typically speaking, the next of kin can apply to the Ontario Public Guardian and Trustee or to the courts, keeping in mind the Ontario Public Guardian and Trustee and Children's Aid. So either Peel, Toronto, Halton Children's Aid, to be that minor's guardian of their what's called the person, guardian of person. Now, we do advise individuals to name a guardian in the body of the will. However, naming an individual in the body of the will does not necessarily mean that that person will become the guardian of that child, of that minor child. They become the de facto upon death, but that person still would have to apply to court to be that child's guardian of that person. Now, the intentions in the will, what we call prima facie or on the face of it, would be the number one choice, would be the preference of the parent. That doesn't necessarily mean that person is the most fit to do so. And someone else can always come in and step in and say, no, this person is undergoing certain issues, or we don't feel this person is the best individual for the child. We feel we are the best person for the child. And then it comes to a matter of adjudication in terms of the courts. So simple answer, we encourage people to name guardians in the body of the will. Having said that, that just because you name someone in the body of the will doesn't necessarily mean that that person will become the end guardian.
So to summarize, even if you name someone, that's a good step, but that someone will have to go to court to prove that they're worthy of being the guardian of the children.
Correct.
Okay.
Correct.
Is there a recommended percentage regarding the split of beneficiaries, especially if the child has disabilities?
There's no recommended percentages. Actually, we make no, we provide no advice with respect to how you should divide your estate. That's very personal. From a religious perspective, there are certain percentages that have to be provided for in the will. Again, we can speak to the Islamic will personally if you'd like to pursue that. That's not something we can discuss here. Other than to say, if you're interested in that, there's a lot of resources online with respect to Islamic wills. So that's one consideration. Another consideration is in terms of capacity or ability or relationship sometimes, right? Some people are estranged from their children and they only want to give them a passing amount, right? A very nominal amount from the estate. So there's nothing set in stone. We definitely wouldn't advise anyone with regards to a specific percentage. For disabilities perspective, again, we'll speak about the Henson Trust. It hasn't come across my desk where a child is treated differently as a result of a disability. It has happened in the past where just to evade or avoid the whole concept of a Henson Trust, that if there's multiple children or two children and one has a disability, that the child with the disability isn't named in the body of the will at all, that everything is given to the children who do not have a disability, and the trust is given to that child who doesn't have a disability, that they'll take care of the child with the disability. I typically, and I will strongly advise against that, simply because that one child doesn't necessarily have to follow through on the moral obligation to take care of the child with a disability. Having a Henson Trust and operating a Henson Trust it's not a huge undertaking, and so I wouldn't really personally feel that to be something to do in the body of the will.
Thank you. And this is the last question for today. Does your law firm determine custodial rights of a child? So for example, I have sole custody of my son. If I suddenly die and I don't want custody to go to his father, would that be something that a will can change, or does it have to go through family law courts?
Has to go through family law courts. Having said that, again, if you have a spouse or an ex-spouse and that person is the paternal or maternal biological child or parent, that person most likely will become the guardian of the child, unless there's other extraneous circumstances that would prevent that from happening in terms of abuse or neglect or other issues in the background that would deem that individual to not be the best person to handle the guardianship of a child. But you would have to go to a family law lawyer to do that, to discuss that.
Thank you so much, Zafir. And we got some feedback in the chat. Thank you. Amazing and detailed answers. Much appreciated. Thank you to everyone who joined us today. Keep an eye out for an email with a survey and a copy of the presentation. Also remember that next week we will have webinar number 2, and we'll focus more specifically on power of attorney and Henson Trust. We kind of touched base a little bit about these topics today, but next week we'll have more dedicated time to discuss your questions around this topic. So thank you so much, and we look forward to have you join us next week as well. Thank you and have a great day.
Thank you so much, everyone. I hope you found it informative. If you have any questions, please reach out to either Amal or Dean or myself, and I would gladly assist any of you. I know it's, as I said, it's not complicated, but at the other hand, it is very complicated. And so there's a lot of things to consider, and I really appreciate everyone attending.
Thank you, Zafir, and thank you everyone else, and have a great day, inshallah. Assalamu alaikum.
Assalamu alaikum.